My name's Fran and welcome to this Acas webinar, Employment Rights Act 2025, Key Measures and Employer Actions. This webinar is the third in our series following the Employment Rights Bill journey to become law. And this webinar is going to focus on the main measures within the bill, now on Act since royal assent has been granted, when the changes are due to be implemented, and what employers can begin thinking about in terms of preparation. Before we get started, just a little bit about who we are and what we do. We provide employers and employees with free, impartial advice on workplace rights, rules, and good practice. We also offer training with some newly developed training to support you with the changes coming in, for example, paternity and parental leave, understanding the law, and proposed changes. We also help resolve disputes, and our website has a number of free template letters, forms and policies for employers, HR managers and employees, which are free to download and use. In this first section, we're going to look at the finalised content of the Employment Rights Act after finishing its journey through Parliament. Before we get into the changes, let's look at an overview of what the Employment Rights Act does. Since the Employment Rights Bill received royal assent, it's now referred to as the Employment Rights Act 2025 and has become law. This doesn't, however, mean all changes will come into force immediately. Most changes will take place over the next couple of years, with the introduction of changes staggered to come in phases through 2026 and 2027. The Act introduces a wide range of reforms across areas such as sick pay, dismissal, and family rights. The Act will change some already existing rights, for example, removing or reducing qualifying periods. It will also introduce some new rights, for example, the right to guaranteed hours. As mentioned, many of the changes are being brought in gradually. One change that will take effect straight away is the minimum service levels for strikes being repealed. However, many of the individual provisions, such as protection against unfair dismissal after 6 months' employment, will come into force on different dates. Many changes are still to be consulted on and will need secondary legislation to be introduced before they come into force. These are due to be phased in across the next 2 years. So this allows time for consultation on some details still to be determined and creation of secondary legislation to set out the details of some of the changes after consultation. Here at Acas, we play a crucial role in supporting the Act's implementation, helping employers and employees prepare for the changes through developing detailed advice on all aspects of the new legislation as they take effect. We'll be updating our statutory codes of practice to ensure employers and workers understand their legal obligations and good working practices. We'll provide a range of training and support, including webinars, workshops, and resources. We will continue to provide expert, impartial conflict resolution through our conciliation and mediation services. You can sign up to our newsletter on our training website for regular updates to law and information about training that we offer. And you can keep track of what's happening and when through our dedicated ER Bill website page. To support implementation of the Employment Rights Act, the government is consulting with employers, workers and representative bodies on specific rights. And you can find out more and get involved at gov.uk. The current consultations are Make Work Pay, Enhanced Dismissal Protections for Pregnant Women and New Mothers, and this is closing on the 15th of January 2026. Make Work Pay, Leave for Bereavement, including pregnancy loss, which is also closing on the 15th of January 2026. And Make Work Pay, Draft Code of Practice on Electronic and Workplace Balloting for Statutory Union Ballots, closing on the 28th of January 2026. You can also sign up for emails to inform you about consultations, and the full links can be found on the slide. There are more consultations expected to start early in 2026. We're now going to take a look at some of the new measures the Employment Rights Act intends to deliver. We'll start by looking at unfair dismissal. The reform on unfair dismissal has changed significantly while going through Parliament. A previous proposal was to introduce unfair dismissal protection from day one alongside an initial period of employment where a new set of rules would apply when dismissing someone. The government changed this before the bill became law to reduce the qualifying period for protection from unfair dismissal from 2 years to 6 months, with a planned implementation of January 2027. This is aimed to increase job security and fair treatment. Some dismissals remain automatically unfair from day one. All other rules around unfair dismissal remain as they are now, with the exception of future plans that the government compensation cap for a successful unfair dismissal award will be removed. It currently sits at 52 weeks pay or £118,233, whichever is lower. Currently, pregnant women and new mothers are protected from discrimination and dismissal linked to pregnancy or maternity leave and have enhanced rights in redundancy situations. The Employment Rights Act provides powers to introduce regulations to extend protection to cover other dismissals, which are not redundancies, taking place during pregnancy and other types of family leave, or following a return to work from family leave. The government is currently running a consultation to gather views on the detail of this reform. It will then create secondary legislation to implement the details of this reform, and this is due to be implemented in 2027. As we mentioned before, there is consultation open until January the 15th on this provision, and this explores options on how to define specific circumstances in which it would or wouldn't be lawful to dismiss any pregnant employee, and how long that protection might last. For example, 6 months after return from maternity or 18 months after birth are among the options being explored. Additionally, dismissal and re-engagement, sometimes referred to as the fire and rehire, is an area where protections have been strengthened. The Act will make it an automatically unfair dismissal where an employee is dismissed and rehired or dismissed and replaced with someone else in order to change specific terms and conditions in their contract, known as restricted variations, unless the employer is in severe financial difficulty and has no reasonable alternative to fire and rehire. A consultation is planned to explore the details of this reform, potentially looking at what types of change to terms and conditions should be included or excluded as a restricted variation. Secondary legislation could be introduced to set these out. The government will also be looking to update the Code of Practice on dismissal and re-engagement and will consult on that publicly. There's no confirmed date for this, but the government intends to commence the fire and rehire provisions in the Employment Rights Bill later in 2026. Let's look now at changes to statutory sick pay under the Employment Rights Act. These changes represent a significant shift in how sickness absence is supported for all employees that get SSP. Under the current system, employees have to wait until day 4 of a sickness absence to be eligible for SSP. The Act provides that sick pay will be paid from the first day they are unwell. Employees also currently have to earn above a minimum weekly threshold, known as the lower earnings limit, to qualify for SSP. That requirement will be removed. And both of these changes are planned to take effect in April 2026. These changes bring many more people into scope to receive sick pay and support people who are on low incomes. The intention is to reduce situations where employees feel forced to work while unwell due to lack of income, which has broader health and productivity implications. Of course, an employer can still choose to top up SSP to full or half pay for their employees, should they choose to do so, but it's important to note that SSP remains a statutory amount rather than full pay and is subject to an employee meeting the qualifying criteria. Think about reviewing sickness absence policies, updating payroll and HR systems, and training managers to understand SSP eligibility. Clear communications with employees will also be essential, so expectations are properly set and working relationships are maintained. This slide brings together several important family-related leave rights and enhanced protections introduced under the Employment Rights Act. The focus is on supporting parents and carers while reducing the risk of disadvantages linked to pregnancy, loss, or caring responsibilities. Significant changes are being made to paternity leave and parental leave, with changes planned to take effect in April 2026. The current qualifying periods for these rights, 26 weeks for paternity and 1 year for parental leave, will be removed, with the Employment Rights Act making them a day one right. This will make paternity and parental leave more accessible and support early bonding and shared caring responsibilities. Employers will need to ensure that managers understand eligibility from day one, that payroll systems can apply statutory paternity pay correctly, and that employees are not discouraged from taking paternity leave even if they've just started their employment. Another important change is the removal of the restriction on taking paternity leave after taking shared parental leave. This would allow partners greater flexibility in how they take their leave, and as a result, might encourage more families to share leave. Historically, shared parental leave has been underused. The Act improves clarity. Employers should prepare for greater awareness and uptake going forward. Bereavement leave will be expanded with a right to unpaid bereavement leave, including following pregnancy loss before 24 weeks, with changes planned to take effect in 2027. The government is currently consulting on how this will work in practice to shape the final details of this new right. It is seeking views on who should be eligible for this leave, potentially including non-traditional family members and various forms of pregnancy loss, as well as the timing, duration, flexibility, notice and evidence requirement for taking leave. The focus here is on providing space to grieve, reducing pressure to return to work too quickly, and protecting employees from unfavourable treatment due to bereavement. Clear policies and compassionate management will be essential. As we've already mentioned, safeguards against detriment, redundancy and dismissal will apply to these rights. This slide looks at one of the most significant areas of reform in the Employment Rights Act, protections for people working irregular hours, including those who work through an agency. These reforms aim to balance flexibility with greater security for workers who currently face unpredictable income insecurity. One of the core proposals is that a worker who has been working regular hours over a set reference period, likely to be around 12 weeks, will have the right to be offered a contract with guaranteed hours reflecting their typical pattern of work, with an exception for seasonal or temporary work. For employers, this means reviewing how zero-hour and low-hour contracts are used and being prepared to offer contracts that reflect actual work patterns once a worker qualifies under the reference period. There will be consultation to determine how this will work, including the details of any exceptions. Secondary legislation is expected to introduce the right in 2027. The right to reasonable notice of scheduled shifts has also been proposed, including notification of changes or cancellations. Employers will need to put systems in place to notify workers of their shifts with sufficient lead time, and they should document communications to demonstrate compliance. If a shift is cancelled or moved at short notice, workers will have a right to compensation. The details will be set out in secondary regulations after consultation. Agency workers will receive the same protections as directly engaged zero-hour or low hours workers, including rights to guaranteed hours, reasonable notice and shift cancellation pay. The agency and hirer will be jointly responsible for giving reasonable notice of changes to shifts to workers. However, the agency will be responsible for any short notice shift cancellation or curtailing payments, though parties can come to an agreement on compensation. So, what can employers do to prepare? They should audit how 0 hours, low hours, and agency arrangements are currently used. They should also review shift scheduling and notice protocols and update contracts. Employers should think about how they will communicate with workers and engage with agencies to clarify responsibilities and monitor regulations that will specify reference periods, notice thresholds, and compensation formulas. This next slide explains the changes to collective redundancy rules being introduced under the Employment Rights Act. These reforms broaden when consultation obligations arise. Currently, collective redundancy consultation is triggered when an employer is proposing to dismiss 20 or more employees at one establishment within a rolling 90-day period. Under the new Act, the site-specific test remains, but a second trigger will be introduced based on redundancies across the employer's entire business, regardless of location. This change is planned to take effect in 2027. Currently, failing to consult properly can result in protective awards up to 90 days pay per employee. This will increase to 180 days pay per affected employee and is expected to take effect from April 2026. We will look at when other changes come into effect later in the presentation. For organisations operating in multiple locations, the introduction of a business-wide collective redundancy trigger means central HR tracking systems are essential. Local site counts will no longer be sufficient. Planning and coordination across the organisation are critical to ensure consultation triggers are identified early. To prepare, review redundancy and consultation policies. Implement central reporting of redundancy plans across all locations, and engage early and genuinely with employee representatives. Early and thorough consultation not only complies with the law, but often leads to better outcomes for both businesses and affected employees. Now, under the Employment Rights Act, a significant structural change has been proposed, the creation of a single enforcement body to cover enforcement of specific rights, known as the Fair Work Agency. The Fair Work Agency, or FWA, is designed to bring together functions currently exercised by various government enforcement teams. And this includes the Employment Agency Standards Inspectorate, HMRC's National Minimum Wage Enforcement Team, and Gangmasters Labour Abuse Authority, which covers modern slavery. The Fair Work Agency will also add new areas for enforcement, such as for holiday pay. This unified approach means workers will have a clear single point of contact for enforcement of specified rights. And the FWA will be able to inspect workplaces for compliance, issue notices requiring payment of underpaid statutory entitlements, for example, statutory sick pay. They'll be able to impose penalties, bring civil proceedings and pursue enforcement through tribunals or courts, and they will be able to provide legal assistance to workers when appropriate. With the creation of the Fair Work Agency comes an expectation that employers will maintain detailed records for holiday pay data. There will be an obligation for employers to keep records for 6 years regarding holiday pay, payment in lieu of holiday, and holiday taken. If an employer fails to comply, it will be punishable by a fine. To prepare for this, employers should review record keeping and payroll systems, and ensure pay and leave entitlements are clearly documented. We're now going to have a look at the timeline and order of changes. So the Employment Rights Act will be implemented in phases over 2025 to 2027. And we're now going to look throughout this section of the webinar at when the multiple reforms are proposed to take effect. So royal assent for the legislation was given on the 18th of December 2025, and this is the point the bill formally became law. As previously mentioned, this does not mean all new rights apply immediately. It will be rolled out in stages over several years. Changes that will take effect 2 months after the date of royal assent on the 18th of December will repeal some parts of the Trade Union Act 2016 and simplify industrial action and ballot notices. Following this, April 2026 is the next major implementation phase. For many organisations, this will be the point where policy updates, system changes and manager training become essential. Beyond April 2026, additional reforms are expected to come into force, particularly where there are changes are more complex and require consultation and secondary legislation. There is only one change that's expected in December 2026, and it's specific to the seafarer industry. The extended timeframe reflects the scale of change and the need for detailed regulations before full implementation, leaving some changes falling into 2027. This phased approach gives employers time to prepare, but it also means compliance planning needs to be ongoing, not a one-off exercise. Track which rights apply at which stage, and we're going to look at that next. So on the 18th of December, we saw royal assent. On royal assent, the Strikes Minimum Service Levels Act was repealed and is no longer in force. This act was designed to require workers to provide a minimum level of service during a strike in certain sectors like health and education services. 2 months after royal assent, the Employment Rights Act will change some rights relating to union activity. These changes won't affect employers or workers who don't have unions, and the changes include the period for giving notice of industrial action will be reduced from 14 to 10 days. Unions will require a simple majority of those voting to approve industrial action rather than specific percentage rules based on the total number eligible to vote. The requirement around picket supervisors will be removed. Industrial action mandates will be extended, so once members have voted to take industrial action, the union will be able to take that action within 12 months rather than 6 months, and the Act will also simplify what must be provided on industrial action notices and ballot notices. There will also be strengthened protection against dismissal for taking part in protected industrial action. So currently, an employee who has taken part in industrial action, for example a strike, is protected from unfair dismissal if the dismissal takes place within 12 weeks of starting the industrial action. The law will remove this 12-week limit, so any dismissal for taking part in industrial action would be automatically unfair at any time. And finally, there will be changes to political fund rules. A trade union may not spend any part of its funds to directly or indirectly benefit a political party unless it has first been approved by members through a vote. Currently, the law requires unions to hold review ballots every 10 years to continue operating a political fund. The new Act will remove the requirement to hold this ballot every 10 years and replace it with the requirement to send out a notice to members reminding them of their right to opt out of contributing to the political fund. It's intended that in April 2026 that the following laws will be introduced. The maximum amount of a collective redundancy protective award will be doubled from 90 days to 180 days pay. April will also see day one rights to paternity leave and unpaid parental leave. Sexual harassment will be added as one of the protected disclosures under whistleblowing protections. This means that someone who has made a qualifying disclosure about sexual harassment will be protected from detriment and dismissal under whistleblowing law. The Fair Work Agency body will be established. As previously mentioned, the removal of the lower earnings limit for statutory sick pay will be removed. Statutory sick pay will also be payable from day one of absence rather than from the 4th day, as it is under current rules. Whilst there has been some concern about this leading to an increase in people taking sick days, it does not impact an employer's ability to effectively manage absence, and employers and employees should still work together to deal with root causes of work-related absence and focus on reducing absence by promoting a healthy working environment. April is also when additional trade union laws will come into force, such as changing how a trade union can gain recognition in a workplace and allowing workers to vote using electronic ballots. The laws we'll see in October 2026 are limiting use of fire and rehire practices. There is an existing statutory code of practice introduced in April 2024. The code states its purpose ensures an employer takes all reasonable steps to explore alternatives to dismissal and engages in meaningful consultation with a view to reach an agreed outcome with employees or their representatives. It seeks to make sure employers do not raise prospect of a dismissal unreasonably early or put undue pressure on employees by threatening dismissal where it is not envisaged. Alongside the updated law on dismissal and re-engagement, the government intends to issue a revised code of practice by October 2026. October 2026 will also see regulations brought forward to establish the Adult Social Care Negotiating Body, which will negotiate fair pay agreements for the sector. The regulations will include what it will do and how it will work in practice. There will also be introduction of a procurement two-tier code. This will set out measures to avoid the creation of a workforce consisting of ex-public sector employees and private sector employees, with each group on different terms and conditions. This will be governed by both regulations and a statutory code of practice. Tipping law will be updated, so employers must consult with workers or their representatives before creating a tipping policy for the workplace. The Act also requires that these policies are reviewed at least every 3 years. There is a public consultation on this planned in early 2026, so if you work in an industry where tipping is commonplace, this might be one to watch out for. In October 2026, employers will have a duty to inform workers of their right to join a trade union, which should be issued alongside their written statement of employment particulars on or before someone's first day of employment. October will also see updated laws on a trade union's right of access to the workplace, with the introduction of a framework for access agreements between an employer and a trade union. This would permit a union to request access rights from the employer for specific purposes: meet, support, represent, recruit, or organise workers or facilitate collective bargaining. Also in October 2026, there will be the introduction of new protections relating to sexual harassment. This includes a duty on employers to prevent third-party harassment and to take all reasonable steps to prevent sexual harassment, and it also includes an obligation for employers not to permit the harassment of their employees by third parties. It will also void clauses in non-disclosure agreements, sometimes referred to as NDAs, that would prevent workers from alleging or disclosing relevant work-related harassment or discrimination. There will also be the introduction of new rights and protections for trade union representatives, which include a right to reasonable accommodation and facilities for trade union representatives when carrying out their duties, and a right to time off for union equality representatives to carry out relevant duties. October 2026 is when the planned extension of employment tribunal time limits will take effect. This increases the time limit to make a claim to 6 months from the current 3-month time frame that applies to most claims currently. The 6-month time limit means that both sides will have more time to take legal advice on the strength of their case. For employers, this will mean that the retention policies under GDPR may need to be amended, as records may need to be kept for longer under the new rules. There will also be extended protections against detriment for taking part in industrial action. So workers taking industrial action will be protected not just from dismissal, but poor treatment short of dismissal. In December 2026, the mandatory Seafarers Charter is expected to take effect. This is sector-specific legislation, but it will set higher standards for seafarers on services regularly calling at UK ports. The protection for seafarers include ensuring fair pay, job security, adequate rest breaks, and health and safety. Most of the 2027 proposals are the subject of public consultations. You can have your say on these and can sign up to be notified of consultations on the gov.uk website. The changes are: unfair dismissal qualifying period is proposed to reduce to 6 months from 2 years. Consider training your managers on effective performance management and how to effectively use probation periods if you don't already have those policies in place. 0-hour and agency workers amendments will take effect in 2027. The law also introduces a right to payment where a shift is cancelled, moved to another date, or cut short by the employer. Flexible working law will be amended. Currently, an employee can request flexible working from their first day of employment, and an employer can only refuse based on one of 8 statutory grounds. For example, it would have a detrimental impact on performance. Under the new changes, an employer still needs one of the 8 reasons to turn down a request, but additionally, the employer must state the grounds for refusing it and must explain why they believe the refusal is reasonable. A consultation will be undertaken in early 2026 before regulations are made and the reform brought into force. Acas will also need to update our code of practice on flexible working to bring it in line with this reform and provide guidance. 2027 will see the introduction of equality action plans on a required basis. Equality action plans will show how employers are addressing the gender pay gap and supporting employees going through the menopause alongside gender pay gap reporting. There will also be regulations to give more protection from dismissal for pregnant workers. In 2027, a power in the Act will come into effect, enabling the government to introduce regulations that will specify what steps are to be regarded as reasonable steps to determine if an employer has taken all reasonable steps to prevent sexual harassment. In 2027, there will also be an extension of the prohibition on blacklisting based on a trade union membership or activity. This is intended to cover lists created by artificial intelligence or predictive technology. There will be a new industry relations framework introduced to foster protective and constructive engagement where disputes arise. Regulation of umbrella companies will take effect in 2027. The Act expands the definition of an agency to include umbrella companies. This enables enforcement by the Employment Agency Standards Inspectorate and then the Fair Work Agency. After the planned consultation on regulation of umbrella companies, the government will amend the law to set out the framework for umbrella companies. 2027 will also see changes to the collective redundancy, collective consultation threshold. And finally, to be introduced in 2027 is the right for all employees to bereavement leave. This is in addition to the already existing right to parental bereavement leave. This includes for parents who experience pregnancy loss, sometimes called a miscarriage, before 20 weeks of pregnancy. So in this last section in this webinar, we have covered what is in the Employment Rights Act, the phase changes and the timelines, and we have already mentioned a few things employers should be considering. We're now going to focus on practical steps employers can take. So on this slide, we're looking at specifically HR and policy updates. With the introduction of more day one rights, employers should review family leave policies to make sure eligibility processes and manager guidance are clear. Absent policies should clearly explain reporting procedures, evidence requirements, and how absence is managed in a fair and supportive way. When unfair dismissal protection is applied from 6 months, probation processes may become even more important. Employers should ensure expectations are clear, feedback is documented, and decisions are fair. The new duty to prevent harassment places a greater emphasis on preventative measures. Policies should be clear on standards of behaviour, reporting routes, and how concerns, including third-party behaviour, are handled. Flexible working policies should clearly explain how requests are handled and how decisions are explained if they aren't already. And with higher protective awards, effective consultation becomes even more important. Policies should reflect meaningful engagement and clear communication. The key part here that this isn't about rewriting every policy at once, but checking that your existing policies are fit for purpose, they're consistently applied, and they're aligned with the changes to the law. So communication plays a key role in how these changes are understood and experienced in the workforce. Employers should be clear about what changes will affect their particular workplace, when those changes are expected to happen. So be open and honest about the phased nature of the changes and what isn't yet confirmed. This can help build credibility and it can set expectations. Inconsistent messaging can undermine trust, so ensure that HR managers, line managers and senior leaders are aligned in what they're communicating about the changes. And engaging with employee representatives and trade unions can help ensure employees and workers are kept informed and consulted. So to close the session, we want to highlight a few final takeaways. The Employment Rights Act brings significant reform, but as we've outlined, it's being introduced in phases. Many of these changes rely on consultation and secondary legislation. Employers, workers and representatives can take part in consultations published on gov.uk. And this is an opportunity to share practical insights on how changes may work in real workplaces. Acas will continue to provide impartial guidance as further details emerge, which leads nicely onto our last slide. So to keep yourself up to date with relevant training and information relating to employment law and good practice, employers and people managers are encouraged to register for free Acas email updates. We're going to be highlighting the publishing of new Acas advice, employer resources and training events, and also providing timely updates on changes to employment law. So sign up to the Acas newsletter on our website. Goodbye for now, and thank you for watching.